Hello, and welcome back to XRP Vault, where we bring you the most recent and intriguing XRP news. We're giving away 10,000 XRP to those who are watching. All you have to do is upvote, subscribe, comment XRP is king and watch the video to the end to be eligible. The winners will be picked next month and publicized on the community page of the channel. How long will cryptocurrency holders continue to trust in Ripple if the SEC attacks which cryptocurrency? What will an extract cost in the middle of 2023? In today's video, we will respond to each of these queries. Until Congress passes legislation establishing a regulatory framework for the cryptocurrency industry, Attorney John Deaton claims that the Securities and Exchange Commission's (SEC) action against Ripple may make it all the way to the U.S. Supreme Court. To put things in perspective, the case is still pending in district court and must first go before the Circuit Court of Appeals before the Supreme Court. The author of the CryptoLaw expressed this stance in a tweet today, which gave away the fact that the government has no plans to scale up its aggressive crypto enforcement efforts. Eleanor Turrott, a Fox Business contributor, disclosed a portion of the SEC's current spending proposal. The government also emphasizes that it will not be reluctant to look into and prosecute cryptocurrency businesses that it deems to be non-compliant. The regulator's crypto enforcement section, which has more than doubled in size in the past year, would likely expand as a result, according to Shred. Deaton reiterates that for the next 2 years, the courts will be the only source of clarification for cryptocurrency, citing tariff conclusions. Yet he admits that it is not ideal. He maintains that the Ripple issue may be heard by the Supreme Court before Congress takes action. "We have to fight in court in January," Deaton tweeted. According to Deaton, the embryonic market would receive the sole explanation it would receive in the following 2 years from the eagerly anticipated ruling in the Ripple lawsuit about the status of XRP as an unregistered security. The attorney emphasized the division of Congress and the sour taste failure leaves in people's mouths when presenting this case. Judge Analisa Torres' impending decision is becoming more significant by the day, said the attorney representing thousands of additional investors in the ongoing complaint against Ripple. Nonetheless, he did express confidence that the federal court will decide that there is no precedent for secondary market transactions of extra-powerful unregistered securities. Torres, in the opinion of Deaton and the judge, is quite strict about following the law. The asset itself is always an investment contract, and hence the premise that sex is criminal cannot be accepted by the court. There hasn't been a case in the 80 years since, Deaton claimed on Twitter, that supports such a judgment. Due to her scrupulous adherence to the law, Judge Torres declines to determine that secondary sales are illegal under Section 5. Deaton asserts that the SEC's lawsuit against Ripple can only be successful if the blockchain payments business issues XRP. Judge Torres' decision last week to deny Dogbert's request to exclude expert testimony was broadly viewed as a Ripple victory with effects from 2013 to 2017. General Counsel Stewart has already stated that each bird increases the firm's trust. Deaton believes the judge's summary judgment ruling will be delivered soon. In the event that Ripple wins its legal battle against the U.S. Securities and Exchange Commission, one of the biggest stories in the XRP ecosystem will be the relisting of the XRP token on the major U.S. crypto exchange Coinbase. In a recent interview, Paul Growal, the chief legal officer of Coinbase, went into great detail about the subject and described the XRP relisting procedure. In January 2021, Coinbase prohibited trading in XRP. Grohl expressed his hope for a Ripple victory in yesterday's conversation with Thinking Crypto presenter Tony Edward, but he also highlighted that a relisting does not entirely depend on a trial court's success. The rule says that the U.S. crypto exchange assesses assets on a regular basis for listing, delisting, or halting. This is despite the vociferous Archer community's request that the coin be reinstated. He is aware of the anxiety felt by the XRP community. Growingall said, "I understand that it has been frustrating for many XRP holders that they have been unable to trade their assets on Coinbase while this sexual action has been ongoing. However, the SEC has not prevented Coinbase from closely monitoring the state of the dispute. All this growth means that everyone else is eagerly awaiting the ruling and praising Ripple's attorney's efforts. I definitely paid attention to how well the defendants in this case pushed the envelope and raised important issues regarding the general fight between the sexes. According to GRU, Coinbase has submitted an amicus brief in support of some of Ripple's arguments, and Ripple's CEO Stuart Alterity and the rest of the fine tech industry have done an outstanding job. For these reasons, he thinks the court will rule in Ripple's favor and will demonstrate that the SEC's theories are flawed. In this case, I think the briefing was excellent, and everyone will soon see what the trial judge decides. Consider the arguments. The Coinbase and context emphasize that the Southern District Court of New York's ruling is only the beginning of a drawn-out process, in his opinion. The timing for relisting after the trial court judgment depends on the reasons for the judgment, the judge's legal justification, and his opinion of whether or not the decision would be upheld by the appeals court, according to Gruel, who believes that regardless of who wins in court, both parties in the case will appeal. As a result, a lot will depend on the specifics of the court judgments. I'm aware that not everyone will find it to their taste, but as a publicly traded company, we must proceed with caution in this matter. Moreover, any token is the focus of a federal court case, Gruel declared. Last but not least, the Coinbase closing announced that the exchange would start the review procedure as soon as the verdict was made public. So, like everyone else, I am interested to see what the court decides. All I can say is that we will start the process to see whether we need to reevaluate our listing decision as soon as we receive the court's judgment. A ruling in the Securities Exchange Commission v. Ripple legal case. The cryptocurrency community is eagerly anticipating the SEC, which is predicted to be released by the end of March. On March 9th, USC lawyer Jeremy Hogan tweeted that U.S. District Court Judge Analisa Torres might have already decided whether or not XRP is a security. Hogan, a pro-XRP lawyer, reached this conclusion after noting that the judge mentioned the securities law case Marine Bank v. Weaver at least 3 times in her most recent judgment, while describing the viewpoint of XRP holders who bought the coin. Hogan also provided a case sample in which he questions whether the object at issue is generally considered to be a security. The most recent court order mentioned the case of Marine Bank v. Weaver at least 3 times in outlining what a reasonable XR customer would have considered when purchasing the EIGRPI problem. Judge Torres' decision on the DOE bear petitions was 57 pages long. Expert testimony was not objected to by either party in the summary judgment. The attorney made his argument, and the court approved and dismissed parts of both parties' requests, so neither Ripple nor the SEC can claim victory. Judge Torres ruled that the principal expert witness for the sexes, Patrick Doody, who was in charge of assessing the purchaser's expectations, could not testify. In contrast, Ripple's experts were permitted to speak about how Ripple's contracts differ from those in the hallway case and how XRP is taxed. While the Dubar motion's ruling was divided evenly, the accounting treatment of XRP and currency specialists on both XRP and XR are all allowed to remain on the record. According to Ripple's chief legal officer Smith Alda, according to Rody, the business is confident in its argument and will ultimately succeed. We had been confident in our case from the beginning, and that confidence has only grown with each judgment, although the added in the interim. Extract supporter. According to attorney John Deaton, the SEC made a serious error by naming Ripple executives Brad Garlinghouse and Chris Larson in its legal case. According to Deaton, the SEC should have looked into Ripple, a company that issues XRP, rather than targeting individuals who aren't directly accountable for the alleged securities violations. Initially, Deaton didn't claim that the judge had stated that the SEC attorneys had put their own interests ahead of upholding the law. The lawyer said that if the company's own employees disobeyed the law, it was unlikely that the legislation could be enforced. The lawsuit might go in one of 5 directions, according to Finn Bold's reporting by Scott Chamberlain, a former attorney and co-founder of the permissionless Layer 2 platform Evernote XRPal. According to Chamberlain, the matter might be resolved by a settlement, which would create precedents for whether or not the court has jurisdiction over XRP purchases conducted abroad. A letter in support of Ripple's fair notice defense has already been submitted, citing a recent Supreme Court ruling. The petition was filed in response to a ruling that limited the ability of the U.S. government to penalize residents for failing to report their foreign financial accounts to the IRS. By emphasizing the necessity for government legislation setting clear limitations on what acts are prohibited, Ripple emphasized the need for regulatory certainty in the Bitcoin industry.